Welcome back, Gregg Jarrett. Let's talk about Rod Rosenstein, the Deputy Attorney General of the United States. For these purposes, the Acting Attorney General of the United States, because Jeff Sessions recused himself. And he appoints a special counsel to investigate Russian collusion and interference related to the Trump campaign. Donald Trump fires Jim Comey. Jim Comey says, after he's fired, that he pushed for a special counsel, and in his book tour he says he's to be credited with triggering that event.
Right.
Rosenstein appoints Mueller.
Right.
I'm a little confused about this, as I assume the American people are. Rosenstein wrote an extensive memo to the Attorney General, who passed it on to the President of the United States, and in that memo he cites former attorneys general, former deputy attorneys general, former U.S. attorney, former whatever, at the Department of Justice and beyond, condemning Comey for what he did in Hillary Clinton's case in the press conference, right?
Right.
Well, if he's appointing Mueller to investigate, among other things, the firing of Comey, which he was involved in, is that not a conflict of interest?
It's a major disqualifying conflict of interest that is actually mandatory under federal regulations. It says shall disqualify yourself, not maybe or should or perhaps, shall. And yet, with impunity, Rod Rosenstein has ignored the conflict of interest. And it's really quite astonishing. I think most law professors of ethics are confounded by his refusal. We know that Robert Mueller, the special counsel, has already interviewed Rod Rosenstein, his boss, as a witness in this case. And, an employee is a special counsel interviewing the boss who's a witness who's presiding over the case. Federal regulations say you cannot be a prosecutor and a witness in the same case. I mean, it's fundamental ethics, legal ethics. It's the kind of stuff for which you get suspended or disbarred. So it makes you wonder what Rosenstein's up to. I believe, and I argue in the book, that James Comey stole government documents, which is potentially criminal, and then leaked them to unauthorized individuals for the sole purpose of appointing his longtime friend, partner, and ally, Robert Mueller, who may be motivated to go after Trump in retribution for the firing of his longtime good friend, James Comey. And Rod Rosenstein, as you point out, is in this. They are thick as thieves, and I find it very interesting that Rosenstein, who's also in legal jeopardy for signing off on the FISA warrant without proper evidence, has been obstructing the efforts of Congress in disclosing information and documents which they are legally entitled to have.
Let me ask you, Brad Smith, about the Appointments Clause of the Constitution. The Constitution has an Appointments Clause. And to sum it up, basically, if you're a principal officer, if you seek to be a principal officer in the executive branch under the President of the United States, he has to nominate the individual, and that person typically gets hearings, maybe not, has to be confirmed by the United States Senate. That's the way the framers wanted it. So we have this special counsel. We have a ruling 30 years ago in a Supreme Court case, Morrison v. Olson. It was challenged. That is, the independent counsel statute. And the court ruled overwhelmingly, with the great Antonin Scalia dissenting. And they tested they provided certain elements in the test. That it's constitutional because the independent counsel is an inferior employee who reports to a superior who oversees the case. And there are specific things that this individual is investigating. So it's not like, say, a U.S. attorney or an assistant attorney general of the United States, all of whom are principal officers, all of whom have to be confirmed by the Senate upon nomination of the President of the United States. Is this case not a little different than Morrison v. Olson in that you have a special counsel who was appointed, as Gregg says, without specific criminal statutory purpose? more of a general investigator who has gone in many directions. He's gone into the Eastern District of Virginia. He's gone into Manhattan, chasing the Manhattan madam or whatever. He pretty much has free rein, signed off by the Deputy Attorney General of the United States. But even a U.S. attorney, depending on what cases they get involved in, that has to be signed off by Main Justice too. Is he not, you may disagree with me, is he not more akin to a U.S. attorney as a principal officer, this special counsel, than an inferior prosecutor? If you disagree, say so.
Well, I think the real sin goes back to the decision in Morrison v. Olson, which is, I believe if I remember right, the case where Antonin Scalia made his wonderful line. He said, "This wolf comes to us in wolf's clothing," talking about how bad that statute was. And I do think what this shows is how bad that decision was, because a superior officer, a principal officer, has the authority, so to speak, to set policy and broad discretion, and an inferior officer does not. But Mueller doesn't really report to anybody. I mean, in theory, he reports to Rod Rosenstein, but in fact, as you point out, he's got a roving brief that seems unlimited to go in almost any direction he wants. And so I don't know if I want to say that this is directly different from Morrison v. Olson. It may just show that Morrison v. Olson, A, is a bad decision, and B, that the and I don't know that you get a constitutional claim out of this, but that his supervisors are simply not doing the job in reining him in. It would be as if you had, you know, some lower level official in the Department of Agriculture just running around the country, you know, doing all kinds of things, and nobody in the Department of Agriculture ever said, hey, you can't keep doing that. So that's how I would tend to look at it. But it certainly shows a real problem, I think both a constitutional and statutory problem with special counsels.
Mr. Mueller will trigger a subpoena to force the president to do something, to testify about obstruction, to testify and perhaps create a perjury situation. Couple of questions. If in fact, as you suggest, Mr. Mueller is an inferior employee, does an inferior employee of the Department of Justice have the power constitutionally to force his boss, the President of the United States, to appear before a grand jury or to appear in person for an interview? What do you think?
I would say no. An inferior officer does not have the legal right or the constitutional right to question a president over exercising his constitutional authority in, for example, firing James Comey, the FBI director. And moreover, as to the issue of collusion, whatever that amorphous crime is that's nowhere in the criminal codes, you have no legal right or basis or justification for questioning a president of the United States about a non-crime. And I think Robert Mueller has come to the realization that he knows that if he were to slap the president with a subpoena, the president would move in a motion to quash, and that Mueller would lose in the federal courts. He might win in a district court, but in front of the United States Supreme Court, Mueller knows that he would lose, which is why he's now relenting to a few questions in writing of the president about what he may or may not know about collusion, but no questions about obstruction of justice.
The president has never appeared before a federal grand jury. Bill Clinton negotiated an out when he was subpoenaed to appear in front of a federal grand jury by Ken Starr's group. It turned out to be a disaster because he was lying. What is your take on this? If a president cannot be indicted while he's in office, if a president has the power to exercise his rights to fire an individual, and let's say he's presented with a subpoena, what does he do?
Well, I mean, he fights it, and he can fight it on a number of grounds, including sometimes executive privilege grounds and so on. But I think the basic point that Gregg's made, that you've made, is that, you know, you can't, the theory is, right, the Attorney General or a special prosecutor, in theory operating under the Attorney General's supervision, can't indict or summon his own boss, who's the president. There's a point worth making here that's ignored. A lot of people say, are you saying the president's above the law? Of course, the answer to that is no. The president can still be prosecuted for those crimes once he leaves office. So if there were, in fact, crimes committed, the president can be held accountable. And I think, although there's some dispute, I think most legal experts agree that the statute of limitations would even toll during that period that he's president and can't be indicted. So I think it does flow, as you suggest. If he can't be indicted, he really can't be forced to testify in front of a grand jury.
I think it's important also for the audience to understand Donald Trump's not making these rules. These are the rules that have been in existence. The Constitution has been in existence. He's dealing with it. And one of the things he has to deal with is to protect the office of the presidency. And those Department of Justice memos say what you gentlemen have just said, which is, and in fact they go further, which is even if the statute of limitation runs, so be it. There are things that you have to weigh when you're dealing with the President of the United States. He's not one of 1,000 judges. He's not one of 535 members of Congress. He's not a lower-level civil officer. He's the only president we have, the only person who's voted on by the entirety of the people. And he comes up every 4 years, so they can remove him. And Congress also has power as well. And that's just the way it is. So a president has to defend the office of the presidency. He has to defend the Constitution generally, even though it'll be said, as you watch the Senate Judiciary Committee hearings the other week, they go on, is he above the law, above the law? Actually, in many respects, it hurts him as an individual citizen. As we said, he doesn't get his day in court, and most individual citizens don't have a special counsel chasing him, his family, his businesses, and ghosts from the past the way that he does. So are we saying then that a subpoena should not issue if Mr. Mueller's following the Constitution? Yes or no?
The subpoena should not issue if he's following the Constitution and the law.
No, clearly not. That's just at that point grandstanding, hoping to make somebody look bad with power you don't have.
We'll be right back. Gregg Jarrett, the special counsel, has this broad authority, and he's chasing down the Manhattan, whatever. He's in the Eastern District of Virginia. He's got Roger Stone targeted, but there is Russian collusion. So why isn't he investigating it?
Well, the collusion, if we can even use that term, certainly collaboration, was with Hillary Clinton and a foreigner, Christopher Steele, a British spy, who used Russian sources to be used in opposition research and to spy on the Trump campaign. Now, her payment to the foreigner establishes that information as a thing of value, which would be a violation of federal campaign election laws. And in fact, in egregious cases, it could be criminal. But I find it astonishing that the president is being investigated over something that is not even remotely collusion, and yet Hillary Clinton's actions, the Democratic National Committee, their efforts, which to me is a violation of the law, is not being investigated.
And yet Mr. Mueller has frequently gone to Rod Rosenstein to get his area of investigation broadened and all kinds of things. Why do you think he hasn't done it in this case?
Because he's biased, and he doesn't want to do anything but focus on Donald Trump. This is the mentality of people in government. This is why they undertook a scheme to clear Hillary Clinton, even though she violated the law. And then they're doubling down. They double down to frame Donald Trump for things he didn't do. So that doesn't fit their purpose.
Brad Smith, on the election law issue, I'm just curious. Gregg raises the point, okay, they spent money for this dossier. They washed it through a law firm. They washed it through Fusion GPS. It includes giving money to a former British spy who is gaining information, accurately or not, from Russians and so forth. Does that raise a campaign issue?
Well, it's not illegal to pay a foreign citizen for your campaign. Or, for example, you can buy your cell phones for your campaign from a British cell phone company, or your paper from a Canadian paper company. So it's not illegal to pay a British spy for something of value.
Is it reportable?
It would be reported. Of course, they reported it simply as legal fees paid to their law firm. That's kind of questionable whether that complies with the reporting requirement or not. But in their defense, I'll say the reporting requirements are very vague there. But it does raise the interesting question is, there seems to be this huge focus on Trump when the one organization that we know was clearly, quote, colluding, which Ms. Gray points out is not a crime, colluding with the Russians, was the Clinton campaign. They hired the British spy to go talk to Russians to get dirt on Trump.
And this information winds up in a FISA court. And for the life of me, I don't understand where these FISA judges are. You practice in federal court, I have too, you have too. If I were a federal judge and I knew that the information that had been presented to me had material holes in it, and that I wasn't told the truth, and I wasn't told all the information, and I put my name on a federal warrant, then I'd want to hold somebody in contempt, and I would hold a hearing to find out what the hell took place. We'll be right back.